Today, we are talking about the Writ of Summons. A writ of summons is a court document used to commence legal proceedings in Singapore. In most cases, the writ is preceded by a letter of demand, which is usually sent on behalf of claimant by his lawyer. As mentioned in my previous video, if the recipient of the letter of demand did not comply with the demand therein, the claimant may then choose to resort to legal action. The writ of summons must be filed in court. Here in Singapore, it is usually filed electronically on the e-litigation portal. The filing can be done by the plaintiff, who is the person or entity commencing the suit, or by his or her appointed lawyer to commence legal proceedings against the named defendant, who is the person or entity being sued. Subsequently, the writ will be processed by the court for issuance. Once issued, the writ must be served personally on the defendant or his lawyers. Service of the writ can be crucial. It is the obligation of the plaintiff to ensure that service of the writ reaches the defendant. Legal proceedings do not continue until service is effected. Personal service is effected by delivery of a copy of the writ to the defendant by hand. Where the plaintiff commences legal proceedings against a company, service of the writ may be effected by serving the writ on an officer of the company, such as the director, or by leaving it at the registered office address of the company. If personal service of the writ is not practical or not possible, the court may allow a substituted service of the writ. For instance, substituted service may be permitted where a defendant leaves Singapore to evade service of the document, or where a defendant is constantly moving from country to country. In my next video, I'll be talking about the statement of claim. This document is usually filed along with the writ of summons. Till next time, thanks for listening.